Well, welcome everyone to Legal Future's Construction Interpretation Issues in Wills webinar, presented by me, Gill Steel of Law Skills Limited. And this webinar can only touch the surface, really, of the considerable history of legal principles behind construing and interpreting wills. There's large sections of Theobald on wills, Williams on wills, to pore over to see the old cases in action. But we also need to focus on the sea change in the law which occurred in a Supreme Court decision in 2014 and examine how to manage the risks when more than one interpretation can be put upon the words used in the will by the testator. Of course, many of these wills are indeed homemade, but there's also mistakes made in professional wills, or not even mistakes, but unanticipated outcomes, which therefore mean we have to interpret the will in accordance with the light of the day in which they're now operating. So my aim in this course is to share with practitioners some practical points on the care which is needed when interpreting wills and how the courts approach the construction of a will, with the result that participants listening will be able to avoid, hopefully, personal liability as to PRs or agents for the PRs advising them for the wrong interpretation of a will, which obviously we don't want to happen. So I've divided this webinar into the following areas. We're going to start with the general principles of law, culminating in that decision in Marley and Rawlins in 2014 in the Supreme Court. I'm then going to examine the horrible thing of Devus Starvit and look at the way costs impact on the work we have to do in this area. And we'll examine some recent cases as a way of illustrating how things are interpreted by the courts and the approach the courts take.